Hi, I'm Luke Nichols with the law firm of Nichols & Green, and I'm going to talk to you a little bit about whether or not you need an attorney for your reckless driving case. Now, I'll be honest, not every single person, not every single case requires hiring an attorney. There's a huge spectrum of possible outcomes, and there's a wide variety of people with a wide variety of goals. And not every single person fits into the same box. There's an exception to every rule. I would say that most people should hire an attorney for their reckless driving cases, but not everyone needs to. However, everybody should get a free consultation before they make that decision. There's no real good reason not to. Practically every criminal defense attorney I know offers free consultations. There's a few who don't. I certainly do. So why not pick up the phone and talk to a professional and get some answers before you decide to go in by yourself and do the case on your own? There's just no reason not to. But let me talk to you a little more specifically about what I mean. Reckless driving is a criminal charge, and if you're convicted, it goes on your permanent criminal record forever. There is no expungement. It does not come off. It will come off your driving record after 11 years if you're a Virginia driver, but it stays on your criminal record forever regardless of what state you're from. So that's a pretty big deal for a lot of people, and that's the number one reason most people call us up, is they do not want that criminal conviction, and it's a highly preventable thing in most cases. So definitely want to go ahead and talk to somebody about that. Reckless driving can also come with potential for jail time and loss of license and even real high fines. Now, most people are not going to go to jail on a reckless driving charge regardless of whether or not they hire an attorney, but some people do. There are some judges here in Virginia that will put people in jail for 1 day for each mile over 90 they do, or for each mile over 35 over the limit they do. So you're going to have a perfect record, you weren't causing anyone any trouble, driving fast on an empty road in the middle of the night, 70 mile per hour zone on the I-66, doesn't matter. 91 miles per hour, you're going to jail. But it's really easy to tell whether or not you're facing jail time. First off, if you show up to court and the judge asks you what you're going to do about an attorney, that means you're in danger of going to jail. That's when you pull the ripcord and say, I'm sorry, Judge, I want to continue with, I'm going to go get a lawyer. Okay, if you ever show up to court and a judge asks you what you're going to do about hiring an attorney, the answer is, I'm going to get one. Okay, because judges only ask that question when you're facing the realistic possibility of going to jail. If a judge looks at your case and says, I think I'm going to put this guy in jail, he has to first ask you that question. But they're only going to ask you once. So once they've asked that question, subsequent judges and subsequent continuances, they don't need to ask it. So if anyone ever asks you in court, a judge ever asks you in court, what are you going to do about getting an attorney? Do you want to hire an attorney? Do you want to, you say yes, and you get out of there as quickly as you can because you are in real danger. Okay, so that's a real obvious, clear sign that you need an attorney. A few miles per hour can make a difference. As before I mentioned, people over 90 can go to jail in some jurisdictions quite easily. In the same jurisdiction, an 89 mile per hour case might not go to jail, but a 90 mile per hour case does, even with the same record and similar facts. So 1-2 miles per hour can make a huge difference in a speed case. With non-speed reckless driving, involving accidents or passing school buses or not keeping your car under control or whatever, it's a little bit harder to predict. They're squirrely cases. Often the attitude of the officer is the biggest indicator. If the officer is upset and wants to see you in jail, you're in real trouble, okay? And if the officer is more laid back, they're better. This isn't a perfect rule. Plenty of people have gone to jail with officers being laid back and cool about things. But just generally speaking, those are if your officer is really gung-ho and really nasty to you on a reckless driving case, or if you feel he was out to get you, you get an attorney, because that is not going to end well. Okay, that is not going to end well. So if you have an officer who's upset at you, if the judge is asking you what you're going to do about an attorney, get an attorney. The other thing is there's, short of going to jail and losing a license, there's a lot of bad things about reckless driving. If you have security clearance, getting a criminal conviction, that's a horrible thing. So if you have security clearance, if you hope of getting security clearance, or if you're in a profession that requires background checks like a lawyer, nurses, even accountants and doctors, things like that, you have to go through background checks. You have a state issued license, and you can lose that license if you commit certain crimes or commit too many crimes. And even if you don't lose your license, you have to report it to the licensing board. You have to explain it. It's a big pain. So, I mean, even if you don't lose your license, you don't want to have to be the guy that has to say, yeah, I got convicted of a crime this year when you renew your license. So if that's something you want to do in the future, something you have currently, security clearance, you're in the military, you have a professional license, it's a big deal. I'll get an attorney. It's just not worth messing around with. If you have a commercial driver's license, get an attorney. This is your livelihood. A reckless driving conviction, or even a speeding ticket over 15 miles per hour can cost you your CDL in certain situations. So don't mess around with it. The other thing is the DMV may take away your license if you get too many points. So for instance, if you accumulate 12 points in 12 months or 18 points in 24 months, as an adult, the DMV is going to put you on DMV probation. That doesn't matter whether you take the driving class and get 5 points or whatever. If you get 12 demerit points in 12 months, you're going to be on probation for the next basically 2 years, some form of probation or another. You don't want that to happen. And reckless driving is a 6-point offense. Speeding over 20 miles per hour, even if it's not criminalized reckless driving, just normal speeding 20 over is 6 points. So if you've gotten any tickets in the last year or so, you can be within striking distance of ending up on 2 years of DMV probation, or if worst case scenario, losing your license through the DMV. Even if the court doesn't take away your license, the DMV can. So this is something to watch out for. Also, there's some states, if you're not from Virginia, some states have really draconian practices when you get a reckless driving charge in Virginia. For instance, for a while, the District of Columbia was suspending everyone's license if they get a reckless driving charge in Virginia, regardless of whether the Virginia court took away their license. Because reckless driving is a much more serious charge in DC, or a much more unusual charge at least. They figured, well, if you're getting a reckless in Virginia, you must have done something terrible. We're going to take away your license. Other states have issues. North Carolina, for instance, will take away your license for, I believe, 30 days, maybe 30 or 60 days, something like that, if you get a speeding ticket or a reckless driving by speed offense, which is more than 15 miles per hour over the posted limit. So, I mean, that's a really serious issue. Just because you're not from Virginia, and just because the Virginia courts don't take away your license, that doesn't mean your home state might not. So it's a really important thing to find out. And what I hope I'm communicating to you is there's a lot of factors that go into the discussion. Also, to be honest, the only reason to not hire an attorney to handle your case is the money. Nobody wants to pay money for an attorney. I get that. That makes a lot of sense. So the question becomes, can your attorney save you more money than they cost? And often the answer is yes. Auto insurance is not cheap for a lot of people. It's not uncommon to spend $300 to $600 a year on auto insurance, and there's many people who spend a lot more than that. A reckless driving conviction, or even a speeding ticket, can result in your insurance going up for the next 3 to 5 years. So imagine if you have a couple $100 increase in your insurance over a 5-year period. That's $1,000. And a reckless driving attorney might not cost that much and might be able to prevent that. So if you can save $1,000 by hiring an attorney for much less than $1,000, that's a good deal. People may hire a reckless driving attorney for the convenience or peace of mind. It's a nerve-wracking process going to court, especially since most of my clients have never been through the criminal justice process. They don't know what it's like. They don't want to have to address the judge or stand up to court. Having someone do that for you will take a lot of stress off your mind, and it's just a big help. Additionally, in many jurisdictions, for certain types of reckless driving cases, we can appear on your behalf. So if you're from New York and you get a reckless by speed ticket in Fairfax County and it's not too serious, You can hire an attorney and we can represent you without you needing to drive back to Virginia to appear in court each time your case comes up. If you don't hire the attorney, you have to show up. And you can get bench warrants and trials in absence and all sorts of horrible things if you don't show up to your reckless driving case, unless it's one of those situations where your attorney can show up in your absence. And this is one of those things that we know these rules like the back of our hands. You call us up and tell us what kind of case you got, which jurisdiction you got. We can tell you very quickly whether or not you can have an attorney show up in your absence. But at any rate, I've given you a lot of information, but the main takeaway point is that there's no reason not to just pick up the phone and get a free consultation from us or another attorney. You can find out exactly what you're facing, what you're charged with, what we can do for you, exactly how much we're going to charge you, what payment plans we have available, and we're going to give you answers to all those questions you have. And then we're going to put it down in writing. We're going to give you a to-do list of things to do to prepare for your case. We're going to give you a contract with our price right there in black and white. And you're going to have as much time as you need to make up your mind on whether or not you hire us. So there's no reason not to take advantage of it. It's just it's a free thing that will save you a lot of potential problems. So at any rate, we hope this was helpful. If you have any questions, if you've been ticketed in Northern Virginia with reckless driving or any other serious traffic offense, give us a call. We're happy to give you a free consultation by phone or in person, and we look forward to talking to you. So at any rate, hope this video was helpful. Thank you for watching.